All right. Good evening or good whatever time of day it is, ladies and gentlemen. This is Attorney Brenton Boyce, your professor for for courtroom testimony, CRJS260. This is my lecture on Chapter 4. Of course, once again, the textbook, Winning Court Testimony for Law Enforcement Officers, The Law, Art, and Science of Effective Court Communication by Matthew J. Medina. So I'm going chapter by chapter. This is our Chapter 4 lecture. So we've already gone through chapters. We're in Section 1 of the textbook, which is the basics. But we're talking Chapter 1. We've gone through Chapter 1, which is the anatomy of trial. So we learn how the trial process works. Chapter 2, the prosecution witness, pretty much what that means, how to prepare, and pretty much what the prosecution's witness what the prosecution witness's place is in the court system. Chapter 3 is about what to do before court and how to prepare. And then Chapter 4, which we're about to talk about, is about persuasion. Now, everything we talk about, of course, this textbook is written kind of towards or for effective law enforcement communication in court, but this really applies to any witness or any person that may be a witness, even lay witnesses in court. So of course, lay witnesses won't necessarily be an expert on something, but they are experts on what they saw. If they're there to testify based upon what they saw, what they witnessed with their eyes, there's no better expert that can talk about that, their point of view and where they were than them. So in effect, they are experts. They're just not experts on a specific subject matter. They're experts on what they perceive. So everything we talk about doesn't just apply to law enforcement officers. It applies to lay speakers or general or regular people that are coming to court to testify. So let's start with Chapter 4, persuasion. And this is kind of weird to even have in this courtroom testimony kind of book because really it's not the witness's job to persuade. The witness, and I know talking to other chapters about in other lectures about the prosecution or the defense, the litigants, whether they're prosecution or defense, their job is to build a cake. So and I always use the analogy of a cake. So let's say we're making the cake, we have our ingredients and we have our layers, right? The entire story or the theory of the case, what they're trying to serve to the jury is the completed cake, right? The cake with all the icing on it. But before they can get there, they have to do stuff to prepare. They have to bake the cake. They have to mix it in the bowl, put all the ingredients in. All those ingredients and all those layers are witnesses. So the attorneys have to use witness testimony to be witness testimony and evidence, which can only get in through witness testimony. They have to use that to build their layer cake. And then in certain situations, depending on how well witnesses do, some witnesses can be the icing, or they can add an effect or be a cherry on top for the cake that they're going to serve to the jury. At that point, once the cake is served, once the cake is fully made, then the persuasion is actually up to the litigant. The witnesses are not persuaders. The witnesses do not make arguments, but their truthful testimony and how well they testify and how well they at least know where their testimony fits in the theory can go a long way to helping the litigant build a persuasive argument and persuade. So even though witnesses aren't persuaders and they're not there to argue, they're there just to testify truthfully and objectively about what happened. How well they do, how believable they are is very important to the litigant, who now has to persuade and build a theory based upon that testimony. So let's talk about persuasion. So it's not necessarily, this chapter is not about preparing you to be a witness that is now kind of predicting arguments and being an arguer from the witness stand and kind of squealing away. You're still there to tell the truth, okay? Just remember that it's always about the truth. Even if the truth can kind of hurt you, that's what it's about. And we'll talk about that. Let's go ahead and dig into the book. One of the most important assets that you have is your reputation. When you're on the jury stand, if you're going to be in law enforcement, you're going to be a witness. If you're going to be in probation and parole, you're going to be called to testify, at parole violation hearings or probation violation hearings. If you are if you go to law school, become a lawyer, you probably aren't going to testify about anything, but you're going to be calling people to testify and preparing your cases. So we can all learn, no matter what the plan is. Even if you're going to go into CSI or forensics, at some point in time in your career, you're going to come to court and testify about something you do or something you found at a crime scene. If you're called to come to court enough, you're going to be there and you're going to develop a reputation. It's very important that in developing your reputation, you probably want to have a reputation for being a truth teller. You don't want to have that. You don't want to have the reputation of a liar. That's a bad reputation to have. That means when you come into court, just your presence there, just you sitting on the jury, if you have a certain reputation, that's going to affect whether it be the prosecutor or defense, is going to affect their case. As a matter of fact, sometimes if you have a bad reputation and you don't tell the truth, and some of this stuff is on the record in the past, that may be able to be used against you on cross-examination when you're trying to be impeached for your reputation for telling the truth. So your truth-telling reputation is important. The best tool of persuasion a person has is his or her reputation for telling the truth. Telling the truth, even when it seems hurtful, wins cases. So it makes you more believable if you're willing to tell the truth about something that may hurt the overall case, but you kept it real and you said, no, I did not see that. This is what I saw. I witnessed this, but I didn't see him shoot the gun. So what that does is it says, well, this person's telling the truth because they told the truth about what they didn't see and they didn't push it. And they said what they knew and what they didn't know. We're gonna believe what they say. We're cool with believing that what they said they did see is true, because they told us what they didn't see instead of trying to lie and getting caught with inaccuracies later. So you see the difference. Effective communication is truthful, clear, and persuasive. If the jury likes you, they are more likely to believe what you're saying than if they do not like you. If you have a reputation for being truthful, and sometimes the reputation you build is right there. So these jurors may not know you, right? You're testifying in front of these people for the first time. But if you come off, so of course, during the trial process, if you're called to be a witness, you're going to be directly examined by the party that's calling you, in this situation, the prosecution. And then you're going to be cross-examined by the defense attorney. If you're telling the truth in cross-examination, you're not gonna, even if what you say, it doesn't necessarily 100% help the prosecutor's case, at least you didn't say anything that hurt it in the sense that it hurt. Well, it may hurt their case, but it doesn't hurt your reputation. So at least the jury in front of you, even though you had to say some things that don't help the case, like I didn't see it, I can't say for sure that I saw the person shoot the gun, but I do know when I got to them, they had the gun in their hand, and we tested for gunshot residue, and they had gunshot residue, but no, I did not see the person shoot the gun. So at least the people can know that when it comes to gunshot residue and you getting the gun that was used and connected to the murder from this person's possession, they can believe that. So you still are building a reputation, even though it's your first time in front of these people, because on cross-examination, at least they're going to know, well, he knows what he knows and he doesn't know what he doesn't know, and he kept it real. So at least he's truthful. So he has a great reputation. We're going to believe what he said he knows. You know what I mean? So that's why being truthful is important in persuasion and helping the litigants in your matter be persuasive. Let's see. You should always speak loudly and slowly so that everyone in the room can hear you and understand you. That doesn't mean speak as if the people listening are remedial, but it does mean speak and be understood. I'm a country guy, so a lot of times I speak, us country people, we like to blur words together sometimes. Of course, when you're in front of a jury testifying, you want to make sure you enunciate and pronounce your words and say everything. So that's all it means. Courtrooms are a forum for persuasion. As a witness for the prosecution, you presumably want the prosecution to win. There is nothing wrong or unethical about wanting your side to win. You just can't fabricate or lie or do anything unethical to push that in their favor. There's nothing wrong with coming to court knowing you want your side to win. That doesn't make you unfair. It doesn't make you biased. You can want one side to win over the other, but in giving your testimony, your testimony must be objective and truthful. So you can give an objectful and truthful testimony, then sit back down and be like, I want us to win. Nothing wrong with that. It doesn't mean, it doesn't mean you're trying to hurt the defendant or trying to be unfair or lie. It just means you're telling the truth, but you think he did it, and it is what it is. And you're rooting for the prosecution. There's nothing wrong with that. You might not want that to show when you're actually on the stand, but there's nothing wrong with coming to court wanting one side to win over the other. That just can't affect your ability to tell the truth. However, your job as a witness is not to persuade. As I said before, you're not the persuader. The litigants are. Your job is just to tell the story, tell what you know, and be as truthful as possible. And it's also when you understand and when you've talked to, at least definitely in law enforcement situations, you have opportunities to kind of talk to the litigant, the prosecuting litigant beforehand. Even if it's a district court case where you literally get to talk to them 5 minutes before trial, you at least get to talk to them about what they're trying to prove and what direction they're trying to go in and how they're going to use your testimony to do that. So you at least know. There's nothing wrong with that. It doesn't mean you're lying or being biased. You just know why you're here today and essentially what part of the theory you're here to prove. So there's nothing wrong with that. But remember, you're not the persuader. You're just there to testify. So your testimony should be truthful, factual, and objective. Nothing more. Your testimony is not an argument. The prosecutor's job is to make the arguments. Yours is to testify. It is the prosecutor's job to both argue and to persuade the judge and the jury. The best prosecution witnesses also understand that although it is not the witness's job to make arguments, a good witness should know what the prosecution is trying to accomplish. As I said before, you should know. You should be prepared to at least know where your testimony and what you did, even if it's something small you're testifying about, you should at least know where that fits in their case. And that lets you also know the importance of your testimony and why it needs to be truthful and accurate and why you need to know what you're talking about. And why, if you don't know what you're talking about, you need to let them know that you don't know what you're talking about so that, at least you're not going to come out as a liar, which would really kill the case. Okay, your testimony, as I said before, it becomes one of the building blocks of the prosecution's, or let's say the litigant for whatever side you're testifying for. It becomes a building block for their argument. If you testify well, the prosecution will use your testimony to build his or her case against the defendant. If you testify poorly, get caught in a lie, the prosecutor will just be stuck with your bad testimony. So either way it goes, once you give the testimony, you can't pull it back in and rewind and act like it never happened. Whether it's good or bad testimony, whether it's truth or a lie, you get caught in a lie, or it's the truth, it's out there. So if it's good testimony, it helps. If it's bad testimony, it hurts and it's not going anywhere. It's there. The prosecutors, of course, have an ethical obligation to make sure the truth is told and not to be biased. And they're also there to promote fairness in the courtroom. So, no attorney is supposed to knowingly put someone on the stand and have them tell a lie something they know is not true. So there's also that. So you also put if you're going to get up there and lie, you may put the prosecutor in the bad place where they look bad, where they look like they put you on the stand to lie and they got you up there telling lies. So sometimes your reputation can spill over into the reputation of the person that called you, and they're just there to ask you questions, right? But now they look like a liar too. It look like they're putting a liar on the stand, so they don't look good. The most important practical reason for you to learn some principles of persuasion is that it prepares you for what you are likely to encounter in the courtroom. So sometimes knowing where you fit in the prosecutor's case or whatever side you're on, the litigant's case, will also let you know what the other side may be trying to get out of you or may try to do to you in cross-examination. Now, it's not about necessarily trying to strategize against cross-examination, because either way it goes, your job is just to tell the truth. So tell the truth whether you're on direct examination or cross-examination. But sometimes it's good to know what angle they may be coming from and how they may attack your credibility. So it just is what it is. You might want to be prepared for that. You need to understand the trial process in general and the specific role that your testimony will play in the process, as I said before. So 3 major things. 1, be honest. The first effective persuasion begins with the speaker. Effective speakers have a reputation for honesty. Second, know your stuff. Second, persuasive speakers have mastered their subject matter. That means whatever you're coming to talk about, you should have studied up. If it's something you eyewitness, you should remember it, run it through, and really kind of test yourself to make sure. I did see him. He had in his left hand. He had on a black shirt. That stuff you want to go back so you know I'm sure about this. So effective testimony equals truth, understandability, trustworthiness, and well-honed or well-shaped and organized and aimed testimony and communication. So you know where you fit. So you need to be truthful and trustworthy, understandable, and so meaning that what comes out of your mouth is understood, and you need to know where you fit so your testimony can be honed to help to help further the theory of the case for whoever's calling you. People are more readily persuaded by likely people who are versed in their subject matter and who know their audience well. So, in closing, we'll review chapter 4. First, your reputation for truthfulness is the most important courtroom asset. Also, know what you're talking about. Third, learn everything you can about your case and how cases work in general and how court works in general. Know the process. 4, your job is to be understood, trusted, and believed. So you want to put truthful testimony out there. You want to be understood first and foremost, because the jury is not going to believe you. It's not even about believing you. It's about not even regarding what you say at all if you're not understood. So you want to be understood. You have to be understood before you can even be believed. But you want to be understood, then trusted, and then believed. So if you're understood and trusted, the belief thing will come in anyway. 5th, let the prosecutor make the arguments. Your job is just to give the story. Your job is essentially just to give testimony, truthful testimony, and objective testimony. You let the litigants do the arguing. 6, effective testimony is truthful testimony. 7, effective testimony is understandable testimony. 8, effective testimony is knowledgeable and therefore worthy of trust. And 9, effective testimony draws its effectiveness from preparation. So that is chapter 4. I know it's very brief, haven't been on here very long. So these chapters in this book aren't very long, but they're packed full of good knowledge. So we don't have to talk hours about something for it to be meaningful, especially in this topic we're talking about in general about preparing and being a great courtroom communicator. So that is chapter 4. Remember, I'm just giving a lecture. This lecture is only to supplement your reading. It's your job to read this textbook. Also, at the end of every chapter in the textbook, we have the review questions, and then not only that, you have the review questions, and then if you can answer them to see if you got them right or wrong, and then you flip it over, and the book tells you the answers right here, so you can get an idea of whether or not you're getting it. That may be very important when it comes to preparing for quizzes in this class. Okay, so without further ado, I'm gonna let you guys go, and you'll hear from me again when we talk about chapter 5. Be good.